I've had the benefit of reading the judgment proposed by His Lordship B.R. Gawai Ji. However, I wish to differ on the reasoning and conclusions arrived at in his judgment with regard to exercise of power by the central government in subsection 2 of section 26 of the Reserve Bank of India Act 1934, hereinafter referred to as the Act for the sake of brevity, by issuance of the impugned notification dated 8th November 2016, hence my separate judgment. By way of preface, I state that the judgment proposed by His Lordship Gawai Ji does not recognize the essential fact that the Act does not envisage initiation of demonetization of banknotes by the central government. Subsection 2 of Section 26 of the Act contemplates demonetization of banknotes at the instance of the Central Board of the Reserve Bank of India, hereinafter referred to as the Act, as the bank. Hence, if demonetization is to be initiated by the central government, such power is derived from entry 36 of list 1 of the 7th schedule to the Constitution, which speaks of currency, coinage, and legal tender foreign exchange. I have quoted the 7 issues, judgments, which were, the references, order dated 16th December 2016, where 9 questions were referred. His Lordship Gawai Ji has reframed the questions referred to this Constitution bench and culled out 6 questions, which have been answered in the erudite judgment proposed by him. My views on each of such questions, as contrasted with those of His Lordship's, have been expressed in a tabular form hereunder for easy reference. It is at the head, I have put that. Then I have stated about the overview regarding the importance of the Reserve Bank of India and the Reserve Bank of India Act 1934. Then I have spoken about the history and instances of demonetization the world over, in France, in the United States of America, Britain, Congo, Ghana, Nigeria, Myanmar, Russia, Venezuela, Zimbabwe, and the history of demonetization in India in the 2 periods of 1947 and 1978. Then, while speaking about the Reserve Bank of India being the bulwark of the Indian economy, I have quoted Internet and Mobile Association of India versus RBI, wherein one of us, we, Ram Suprapatyam J, while dealing with the regulation of cryptocurrency and virtual currency, highlighted the importance of the bank in the Indian economy. Then I have spoken about the economic and fiscal policies interference by the court and cited the judgments. What emerges from an understanding of the decisions referred to above or the subject of judicial review of economic policy may be culled out as under: 1. That the court is not to sit in judgment over the merits of economic or financial policy. 2. That the scope of interference by a court is limited to instances where the impugned scheme or legislation in the economic arena has been enacted in violation of any constitutional or statutory provisions. 3. That the court may not undertake a foray into the merits, demerits, sufficiency or lack thereof, success in realizing the objectives, etc., of an economic policy, as such an analysis is the prerogative of the government in consultation with experts in the field. Being mindful of the limited scope of judicial review permissible in matters concerning economic policy decisions, I shall limit my examination of the matter to such extent as is necessary for the purpose of determining whether the process concluding in the issuance of the impugned notification was correct or as being contrary to subsection 2 of section 26 of the Act and allied aspects of the case. It may be stated at this juncture that the said aspect of the matter is not one of form, but of substance. Therefore, examining this aspect of the matter would not amount to interfering with or sitting in judgment over the merits of the policy of demonetization, and is therefore well within the limits of the Lakshman Rekha that this court has carefully drawn for itself. Then I have analyzed section 26 of the Act interpretation. There I have made again a table with a view to lend perspective to the issue with the discussion to follow. A bird's eye view of my analysis and conclusion has been expressed in a tabular form. The parameters for distinction Then second, when the proposal for demonetization originates by way of a recommendation by the central board of the bank. And the third is when the proposal for demonetization originates from the central government, as in the instant case. In that, I would say role of the central government, and the second parameter is role of the bank. The third parameter is extent of demonetization that may be proposed and carried out. Fourth, considerations for proposed measures of demonetization illustrative. Five, process or route to be followed to carry out demonetization. And six, applicability of subsection 2 of section 26 of the Reserve Bank of India Act. Proposal for demonetization can emanate either from the central government or from the central board of the bank. It is, however, necessary to contrast the proposal for demonetization initiated by the central government with that initiated by the central board of the bank. When the bank recommends demonetization, it is, in my view, only for a particular series of banknotes of a particular denomination, as specified in the recommendation made under subsection 2 of section 20 of the Act. The word any in subsection 2 cannot be read to mean all. If read as specified or particular, as against all, in my view, it would not suffer from arbitrariness or suffer from unguided discretion being given to the central bank of the board of the bank. On the other hand, in my view, the central government has the power to demonetize all series of banknotes of all denominations if the need for such a measure arises. It cannot be restricted to such powers in such manner as the central board of the bank is under the above provision. This is because such power is not exercised under subsection 2 of section 26 of the Act, but is exercised notwithstanding the said provision by the central government. Therefore, demonetization of banknotes at the behest of the central government is a far more serious issue, having wider ramifications on the economy and on the citizens, as compared to demonetization of banknotes of a given series of a given denomination on the recommendation of the central board of the bank by issuance of a gazette notification by the central government. Therefore, in my considered view, the powers of the central government being vast, the same have to be exercised only through a plenary legislation or a legislative process rather than by an executive act by the issuance of a notification in the Gazette of India. It is necessary that the Parliament, which consists of the representatives of the people of this country, discusses the matter and thereafter approves and supports the implementation of the scheme of demonetization. The central government, as already noted, could have several compulsions for initiating demonetization of the banknotes already in circulation in the economy, and it could do so even in the absence of a recommendation as per subsection 2 of section 26 Act of the Central Board of the Bank. On its bank to demonetize the banknotes, the advice or opinion of the central bank, which has to be consulted, may not always be in support of the proposal of the central government, as in the year 1978. The central board may give a negative opinion or a concurring opinion. In either of the situations, the central government may proceed to demonetize the banknotes, but only through a legislative process, either through an ordinance followed by a legislation if the parliament is not in session, or by a plenary legislation before the parliament, and depending upon the passage of the bill as an act, carry out its proposal of demonetization. Then they have given the reasons for the same. And I have said why it should be through the legislative process. A parliament is often referred to as a nation in miniature. It is the basis for democracy. A parliament provides representation of the people of a country and makes their voices heard. Without a parliament, a democracy cannot thrive. Every democratic country needs a parliament for the smooth conduct of its governance and to give meaning to democracy in the true sense. Parliament, which is the center of our democracy, cannot be left aloof in a matter of such importance. Its views on the subject of demonetization are critical and of utmost importance. Since nobody states that the impugned Gazette notification dated 8 November 2016 of the central government was published on the initiation of a proposal of demonetization by the Central Board of the Bank. Proposal for demonetization was initiated by the central government by a letter dated 7th November 2016, addressed by the Finance Secretary to the Governor of the bank. The central government, having obtained the advice of the bank on its proposal, proceeded to issue the Gazette notification on the very next day, dated 8th November 2016. The same was followed by an ordinance and thereafter an enactment was passed. Then in the incident case, I have said whether the central board of the bank was in a position to visualize the objectives in the incident case. Under what circumstances the central government was consulted by the central board of the bank was consulted by the central government. Then deciphering the plain meaning of subsection 2 of section 26. I said the plain meaning has to be given to this provision. Then I have said that section 3 of the Act, which was also in the clause 3 of the ordinance itself, is read with inherent contradiction because it says, notwithstanding anything contained in the Reserve Bank of India Act 1934 or any other law for the time being in force, and then says the 8th November 2016 notification issued under subsection 2 of 26. Section 26. Therefore, there is an inherent contradiction there in the provision itself. Then I have gone to the affidavits and record of the case, and the Government of India as well as the Reserve Bank of India, each of them gave 4 documents they have been looked into. And on looking into the records, I find that the use of the words or phrases such as desired by the central government. Government had recommended the withdrawal of legal tender of existing 500 and rupees 1000 notes. Recommendation has been obtained, etc. are self-explanatory. This demonstrates that there was no independent application of mind by the bank. Neither was there any time for the bank to apply its mind in such a serious issue. This observation is being made having regard to the fact that the entire exercise of demonetization of all series of banknotes of rupees 500 and rupees 1000 was carried out in 24 hours. A situation where an independent authority such as the bank, based on its own appreciation of the economic climate of the country, recommends a measure to the central government must be contrasted with another situation where a measure which originates from the central government is simply based upon such independent authority for seeking advice or opinion on such proposed measure. Proposal of the central government on a certain scheme having serious economic ramification has to be placed before the bank to seek its expert opinion as to its viability of such a scheme. The bank as an expert body may render advice on such a proposal and on some occasions may even concur with the same. However, even such concurrence to a proposal originating from the central government is not akin to an original recommendation of the central board of the bank within the meaning of section 26, subsection 2 of the Act. Then I have gone through the affidavits of the Union of India and contrasted it with the affidavits of the bank. On a close reading of the notification dated 8th November 2016, in juxtaposition with the records, the following aspects emerge. One aspect of the matter which emerges with no ambiguity is that the proposal for demonetization originated from the central government by way of its letter addressed to the bank dated 7th November 2016. This aspect forms the central plank of the controversy at hand, that the recommendation did not originate from the bank under subsection 2 of section 26 of the Act, but was obtained from the bank in the form of an opinion on the proposal for demonetization submitted by the central government. Such an opinion could not be considered to be a recommendation as required by the central government in order to proceed under subsection 2 of section 26 of the Act. Even if it is assumed for the sake of argument that the said opinion was in fact a recommendation under subsection 2 of section 26 of the Act. In light of the interpretation given by me herein above to the phrase any series or any denomination means specified series or specified denomination, the recommendation itself is void inasmuch as it pertains to demonetization of all.
ഏറ്റവും പുതിയ വാർത്തകളും വിശേഷങ്ങളും അതിവേഗത്തിൽ അറിയാൻ സീ മലയാളം ന്യൂസ് ആപ്പ് ഡൗൺലോഡ് ചെയ്യൂ. സന്ദർശിക്കൂ www.zeemalayalamnews.com.